You're welcome to
You really shouldn't be doing that. Okay.
So we're all good.
You know you have to go here. Go
Like
like that.
So this is the view that everybody sees, though.
Yeah.
And then they'll follow the slides. Okay.
No, don't stop sharing. Go here. Just work on it from here.
No, I'm not going to do anything other than what you set up for me because it'll crash and burn.
Just go to the other tab. Just hit this one, right?
Okay. If I want to see it.
Yeah. And then go, yeah.
Okay. You like that? Okay. And then you can just give me the thumbs up. All right. Hey, David, can you see me okay?
I can.
All right. Great. I can see you. I can hear you. You can obviously hear me because you responded. Just want to make sure. All right. Here we go. Okay. Lovely. All right. So we'll go ahead and get started right away. So, David, thank you again for joining us. So, for
You're welcome.
everybody else, thank you again for joining us for another edition of STEPP. This is Stabilizing Tenancy Eviction Prevention Program. This is course 9. Today, we are going to be talking about rooming and boarding homes and mobile park homes. So, STEPP, again, just to let you know, is an acronym, STEPP. It stands for, again, Stabilizing Tenancy Eviction Prevention Program. So this is part of a multi-course series. It is a lecture series based on landlord-tenant law or tenancy law here in the state of New Jersey. So this is a grant-funded program which has been funded generously by the New Jersey State Bar Foundation. So I would like to firstly extend my deepest and sincerest gratitude and thanks to the NJSBF for your generous contribution to this program. We wouldn't be able to convey this really pivotal and really important, engaging information that we feel everybody needs to have in New Jersey. So thank you to them for that generous contribution. And thank you to attending and enjoying the class as we've been enjoying presenting it to you. So of course, we are now at course 9. We're in week 9. This has been part of a 10-course series. We've touched on a range of topics. So we started with housing discrimination, familiarizing yourself with the law. In fact, we have some slides that are devoted to that. So if you take a look at our timeline here, we started with housing discrimination, familiarizing yourself with the law. Then we touched on things like rent increases, habitability, lease termination, and property retrieval. Now we are at, again, rooms, boarding houses, and mobile homes. And joining us this evening as our first and only repeat guest is David Saltzman, who we are thrilled to have. He's been a wonderful guest and can't, again, thank you enough for your time and attention and devotion to the subject matter. Our clients, our attendees, prospective clients, and anybody who's interested in being part of the solution to the tenancy issues in the state of New Jersey really are going to benefit greatly from your legal acumen, your advice, and everything that you bring to these presentations. So thank you again, David, for joining us. So we're going to go.
You're absolutely welcome, and I'm happy to be here. Thank you.
Thank you, David. Appreciate that. And we're going to get into David's background a little bit and do a formal introduction. Before we jump into that, I just want to, as we get started on the coursework, just present a disclaimer to everybody. So it's important for us here at Family Promise of Sussex County to let you know that FPSC, Family Promise, is not a legal service provider. We are a housing agency. We're a 501c3 nonprofit charitable organization devoted to those who are facing street homelessness or housing insecurity. We help pay rental arrears or divert eviction in those instances, or we help rehouse those folks who are plagued with the crisis of street homelessness. That is what we do exclusively, whether it be our case management or other services that we provide, whether it be financial literacy, resume building, all of those services. We do strictly those services. So we cannot provide you with legal advice. We are not licensed attorneys. I am not a licensed attorney. No one on staff here is a licensed attorney. Mr. Saltzman is a barred licensed attorney. He can give legal advice, but we cannot give you anything that has a legal consequence on, with regard to a case that you're experiencing or any kind of advice that you may need. So if you have any issues that require such advice, we will refer you to Legal Services of Northwest Jersey. And they've been an amazing, incredible resource. I started, learning about tenancy law as a resource navigator. We were operating under a CEDD grant, which stands for Comprehensive Eviction Defense and Diversion. Went to court, and that grant allowed us to bridge the gap between the courtroom and the litigation going on there between tenants who are at risk of losing their home through the eviction process, and connecting them to social services in the area. Learned a lot about tenancy law, and that's where I met Mr. Saltzman, who is a managing attorney at Legal Services of Northwest Jersey. And we've worked a lot together on cases. We've had mutual clients where we've paid the rental arrears, and we have been part of the brainstorming process that has helped resolve their cases. Of course, David and his staff handle the legal side. Family Promise comes in on the social service sides to help resolve the issues, whether it be a crisis of faith, mental health struggle, substance abuse, domestic violence, whatever it may be. We worked in tandem to help resolve those issues. So I learned a lot. It allowed me to help develop this curriculum here, but I wouldn't be able to do it without, again, the wonderful contributions of our special guests, including Mr. Saltzman. So let's go ahead and get started with this evening's course. We're going to jump right in. But Mr. Saltzman, if you don't mind, I know you've already been a wonderful guest for us in the past as we discussed, our previous curriculum, as well as some of your colleagues at Legal Services of Northwest Jersey. But if you don't mind, for those who are attending who are new, we do have some live attendees today, as well as online attendees. And we would like to know a little bit more. Of course, I already am familiar with you, but would you mind giving us a little bit of background, where you studied law, how you came to Legal Services of New Jersey, and why tenancy law?
Sure. Thank you. I appreciate that, Frank. So, I've been a lawyer for 24 years now. I went to law school at New York Law School in Manhattan. I knew that that's where I wanted to be. That's where I wanted to study law. I was admitted originally both in New York and New Jersey, but I decided I wanted to practice exclusively here, closer to my home. September 11th did that a little bit to some folks.
Sure. Wow.
And so I practiced in the private bar doing various things, a lot of real estate, a lot of litigation in the first 8 years of my career. And to be candid, I worked in-house as an attorney at a real estate development company. And around 2008, all real estate deals, transactions, and things stopped. And so I looked around, saw what I could do, and I made the leap over to legal services. It was one of really the better leaps that I've ever made in my life. And I'm happy I did so. So when I first started at Legal Services, I did almost exclusively foreclosure law for the first couple of 2-3 years. This was during 2008, 2009. And eventually I made a segue into tenancy law. And I started doing tenancy law, and the more I did it, the more I liked it. And the more I continued to do it, the more I even liked it. And so here I am. Now I'm the housing team leader. So I'm the subject matter leader for all the attorneys in my office. I'm responsible for training our new attorneys. We have a pro bono program where we have attorneys come in who want to volunteer their time at other corporations who want to volunteer with us. And so I'm responsible for training those folks as well. And so I do 100% of my time is directed towards tenancy law. I do it all the time. It's what I do. It's what I know. It's what I love. So that's me. Thank you for being here, and thank you for listening.
That's great. Thank you so much, David. And again, really just thank you so much for your time this evening, and seeing you in action, and again, knowing that you devote your practice to exclusively tenancy law. I know, one, that your clients are so grateful to the wonderful services that you provide. And again, you are, I mean, really super qualified to answer our questions this evening, and we're so happy to have you here. So why don't we go ahead and crack right into the subject matter? So again, touching on rooming, boarding homes, and mobile homes as well. So the first thing I wanted to ask you, David, is what types of individuals do you most commonly see as renters of rooming and boarding homes? So in your representation of clients, who typically are the renters of rooms and boarding homes in the state of New Jersey?
So my experience tells me that it's really single folks, right? And to a large extent, more likely single men. Rooming houses in New Jersey, they're a little bit of, well, a mixed bag is what I want to say, right? Some are fine. There are plenty that are not so fine and not so terrific, but mostly it's men who've either, single, been divorced or whatever, who end up living there.
Okay. Okay. And do you find yourself representing clients of this type of tenancy often, or is it more the traditional rental types?
So I think it's really more the traditional rental types. I think in the past, I practice mostly in Morris County, and in Morris County, when I first started practicing, when I first landed here, there were more rooming houses. And I think over time, with the increase in valuation of real estate, I think there are just less rooming houses here in the county of Morris, and I think overall throughout the state. And so I see them less often.
I got you. Okay. And for those that you, in the, I'll say, limited capacity or not as common representation of those who, occupy these particular types of dwellings, what are the most common issues that you see litigated amongst occupants of rooming and boarding homes?
I think really it's non-payment of rent, right? Non-payment of rent, and there seems to be if there's single folks who are doing this, sometimes what happens is sometimes folks who end up in boarding houses might have some issues, right? They might have substance abuse issues, they might have alcohol abuse issues, and so sometimes what happens is, even if it's not them, maybe it's some of the people who live in boarding houses. They don't necessarily get along, and so there's a lot of interpersonal conflict. Has been my experience. Doesn't mean everywhere, but that's been my experience.
Gotcha. Gotcha. And if you could, just as we're touching on the topic in a general sense, just for our audience to know, can you kind of break down and I just want to transition or pivot just briefly to mobile homes, because we've been touching on just rooming and boarding houses as we're cracking into the material, but as it pertains to mobile homes, one of the things that I kind of am a bit confused about as a layperson is the tenancy itself. Do mobile home renters or tenants, do they own the mobile home? Do they own the lot? Do they rent the mobile home? Do they rent the lot? Can you clarify that for our audience?
So I think the simplest answer is I can't clarify it, but here's why. Because it really comes in every variety and flavor, right? So there are some mobile home parks that where people do in fact own the trailer, and they pay rent for what they call the ground rent, literally renting the ground where they sit, and of course they would get services, water services coming in, sewage services and the like. There are sometimes when folks get evicted off of mobile home grounds, there are sometimes they don't take the units for whatever reason, and so there are times where folks come along and they'll rent a unit that's owned by the park, and so there's that type of variety as well, and so it sort of comes in all different ways.
Excellent. Okay, very good. Well, that that helps me a lot because I wasn't sure which way it goes, but it's good to know that it's a variety of things, and it just depends on the circumstances. But as we move along, what I want to now move into for our attendees and class attendees at large is whether they're live or whether they're virtual this evening. I'd like to move into the protections. Now we'll pivot back, and again, that was just to kind of entertain. And I apologize, ADHD brain. So I just wanted to ask about mobile homes briefly as that question popped up in my mind. But now that if we can pivot back into boarding houses and rooms, let's talk about protections for rooming and boarding house residents. Could you explain to us in your capacity, just kind of to give us a general understanding as to what the Rooming and Boarding House Act is?
Sure, it's really an act. There, in the past, they used to call them, kind of even before I passed the bar, an SRO rather, a single room occupancy, and there was an act that was based upon that. As time goes on, we want to get better at things, and so what you found was a new way of classifying boarding houses. Give me 1 second, I got to clear my throat. So boarding houses are really a neglected area within the law, right? Simply put, boarding houses, they're going to be subject to the responsibilities and the obligations imposed upon them by the New Jersey Department of Community Affairs or the DCA. They're all each and every year subject to inspection by the DCA. Boarding houses sometimes don't always get inspected on an annual basis. Sometimes are kind of sort of substandard housing. Sometimes they're frequently above a bar. They're not where you'd want to bring your family, and that's okay because they're not designed for families. But sometimes they're not where folks who don't necessarily want to live. And so you're right in indicating here that DCA will at least should inspect and review that each home is safe and decent. But I think they often don't. And right. And so what you'll find there is just a mishmash of rights not being observed, rights not being cared for. The landlord, in every instance in a tenancy matter, almost always, landlord just wants to get paid, right? And I think what you'll find is that rooming houses that I've experienced, again, within Morris County, right? The operator of the rooming house seems to be a lot more involved in it than most landlords are. There's a lot of heavy interpersonal action, and so folks, again, maybe have drug or alcohol abuse issues, and so it's a mishmash.
Sure, sure. And you had mentioned the DCA, and what exactly? And again, I'm aware as a grantee, here at Family Promise of Sussex County, we're certainly aware of what the DCA is. Would you mind, if you don't mind, explaining for our audience who may not be as familiar with the DCA, what exactly they do? And it can be in a general sense, or you can focus it or funnel it to the capacity as to inspecting or overseeing the licensure for these rooming and boarding houses. What exactly is the DCA in this capacity?
Sure. So it's a New Jersey Department of Community Affairs, right? Which is really an amorphous sounding name. They do lots and lots of things. Just for the moment, in answering your question, I'm just going to focus on the housing related issues. Sure. One, they fund programs. Two, right now, still post COVID, they're giving out rental assistance for folks who are in need. They do inspections of boarding houses. They do inspections of hotels, I think, as well. I might be incorrect about that one. But they also do multi-unit rentals. Anything more than 4 units are subject to inspection by the DCA. And so statewide, think about all of the highways throughout the state of New Jersey and all of the garden apartments and the like that are sitting on the side of those New Jersey highways. All of those are subject to inspection by the DCA. Certainly, many times they're also subject to a dual inspection by the individual municipality, wherever it is that the property lies. So DCA does really a lot as it relates to housing. They also have a homelessness prevention program, which in the past, not so much right now, they provided different additional funding as well. And so they provide some of that funding to other helping agencies, such as Family Promise of Sussex County, so that they can distribute those funds and try to help people preserve their housing.
Excellent, excellent. Thank you, David. So I know, just to back it up a little bit, I know you had mentioned that the DCA is responsible for, and it, as indicated on our slides, that the rooming house dwelling is safe and decent. Are you able to provide us, our audience, with examples of what that means when you say safe and decent housing? What exactly is within the DCA's purview when they do such an inspection?
Sure. Well, so especially for a rooming and boarding house, right? What's important here is, right, that in a rooming house context, right, and really rooming and boarding, right, we're not looking frequently at a whole apartment, right? What we're looking at is simply a room, right? A room, and in theory, the room's got to have some heat. It doesn't need to have any plumbing. It's got to have some electricity, but it's not required to have a sink or refrigerator or a stove or other ability to cook. I mentioned earlier that the Act was previously called these units SROs, single room occupancies, right? But that's really what they are. It's just frequently a single room. The bathroom facilities are frequently sort of down the hall, and they're shared by people who live in rooming and boarding houses. And so when they do inspections, right, DCA is generally looking forward to making sure that that the lights are working, that the windows are not all broken out, right? That it's a habitable place for folks to live. They're not generally looking for bed bugs. They're not generally looking for invasions of varmints, mice, rats, and the like. What they're generally looking for is again just the place is there and has all of the safety precautions. So that means fire extinguishers. That means smoke detectors. It means to make sure that they have an adequate number of doors in and out, things like that. So that's what they're looking for overall.
Okay, excellent. Okay. And what does the DCA do in those instances if they discover a problem when inspecting this like registered room or licensed room or boarding house? What's the process there if they find a violation?
So if they find violations, what they can do simply is they can issue a warning. Generally speaking, they'll start off by issuing a warning, then they can issue like a kind of a state summons, and levy penalties, and eventually, if repairs aren't made, they could shut the place down. And so generally, they'll start off with just saying, "Hey, this stair number 3 is broken on the first level, or there's no fire extinguishers, or there's windows broken at the end of the hall, and things like that."
Mhm.
And so they'll issue those types of letters, and they'll give, generally speaking, DCA is pretty landlord friendly in the way that they'll give you some time to fix these things up. They're not going to, give you letter 1, 2, and 3 within the same week. They'll give you a couple weeks to fix things up, and they'll come back and inspect. It does take kind of sort of quite a bit before DCA will shut down a landlord of a rooming and boarding house. They generally don't do that right away. And there's something vital about it, right? Is that for most folks, they don't live in a rooming house, or they may not want to live in a rooming house. But if a rooming house is shut down, right, frequently we're talking about, I don't know, I mean, they can be bigger, right? But at least 5, 10, 15, 20 people live there, single persons. And so generally what happens is, if they shut that place down, there's going to be 5, 10, 15, 20 people who are homeless. And so there is a general concern, I think, on the part of DCA that unless it's really, really bad, they may not want to shut the place down.
I see.
And so give them some time to repair, to get things up to snuff. And if not, they can begin again to the next step, where they levy fines and penalties. And again, I think they're still not so quick to want to shut the place down. But if that doesn't happen, they can eventually shut the place down. Sometimes just like anything else, there's good rooming houses and there's bad rooming houses in any place. And so the bad ones usually end up eventually with DCA catching up to them, and it's not, they don't get shut down because it's their first bad thing. It's because it's their 26th bad thing. They don't ever have smoke detectors. They don't ever have fire alarms. And so eventually the bad ones get shut down. And the funny thing is, in tenancy court, because I'm there every Thursday in tenancy court in Morris County. And by the way, in Sussex County, we have 2 attorneys who appear there on a weekly basis as well. The boarding houses, you just sort of don't hear from them anymore. You don't even know that they're officially shut down. And so sometimes that happens.
Interesting.
I
Okay.
think really over time, it's a housing resource, if you can call it a resource, that is slowly not going away, but becoming smaller.
Sure. Yeah. And I would say, and I would agree with that, in my capacity as a resource navigator in the eviction diversion sense, a lot of the clients that we deal with, I typically do not come across it as much. It certainly exists. We have clients who occupy rooms and boarding houses for sure, and hotel rooms as well. But like you said, it's kind of carved out as a more nuanced dwelling or residence as opposed to your more traditional tenancies. So that's a definite true observation. So And as I've been, reading along or researching on this particular topic, again, the LSNJ Landlord Tenant Manual is our roadmap in STEP. One of the things that I came across, and as we see if there is a violation, that a written notice is given by the DCA to the owner of the dwelling or the house, the rooming house or the boarding house, that states the date and time by which they have to correct the violations, and if they're not made, the house can be closed or violations can be, or fines can be levied. One thing that I wanted to ask you about, though, that I found that I needed some clarification on was this third option, in that a court can ask or appoint a receiver. Can you help define for our audience what a receiver is?
Sure. I think to respond to that, receiver is called a shorthand for a rent receiver, right? Um, Again, because we have less and less boarding houses, right? And I want to sort of address this way. Boarding houses get subsumed when there's enough hotel rooms, because people end up going into hotel rooms because maybe they're in a better condition and they have a bathroom in the room. Then extended stay hotels came along and they were a little bit better, a lot more expensive, but a little bit better. And so sometimes what you had is, the more hotels there are, the less rooming houses there are. Um, and so, Frank, I answered and then got away from your question. What was the original question?
So I'm asking, like, what a like a receiver is. So they're
Rent
asking, like,
receiver.
yeah. So
Rent receiver.
I guess maybe what I'm asking is there somebody that they appoint, from the court appoints, in the event that the DCA finds a violation? What exactly do they do? Do they go to court, and then what does the court do to ensure that these violations are corrected? Do they appoint someone from the municipality or the township to oversee that these violations are corrected?
Fair question. And so I'll answer it directly this time so I don't forget it. Um, Simply put, it's usually someone who has a financial interest in the property, right?
Okay.
And so if there's a mortgagee, right, a lender who's lent money on the property, the real estate, very frequently they can be a rent receiver. If not, I suppose if that property was owned free and clear, and the town might appoint a rent receiver. I don't know who would do such a things. Most often, when we see a rent receiver in New Jersey, we're really looking in the foreclosure context, when the original borrower is sort of out of the picture, and the bank wants themselves to be appointed the rent receiver. So they can make repairs and they can do all the things that are vital to running the place. They can pay the water bill, so there's water coming into the building so folks can bathe, right? They can do all those services, but they also will collect the rent. The theory goes, when a bank does this, it's because, if your mortgage payment is $3,000 a month, right, but you're getting $5,000 a month in rent, right, that they need to be able to collect that additional 2,000 and pay it over to themselves because they provided the loan, so they would get payment on their interest. Um, that's really it. And so, in a context where there isn't a bank loan, again, I think it could be the town, it could be anyone who's interested, but most often it's really, if the town's not paid, it would go to a tax sale foreclosure. And so it's most often in a bank context with a foreclosure pending or something like that.
Okay, I see. All right. Well, thank you for enlightening me and our audience on that. That was just something I was curious about as I read through the literature on this topic. So thank you for expanding on that. So
No, you're welcome.
let's go ahead and move into, and we're going to crack into the next slide momentarily. But as we wrap up this facet of rooming and boarding houses and the Rooming and Boarding House Act, one thing that I wanted to ask you about, David, was the protections against evictions. Are the So one thing I wanted to ask you about, what exactly, and we've covered this in other classes as it pertains to evictions generally, but if you could just let our audience know, what exactly is the Anti-Eviction Act?
It's my favorite question ever, right? The Anti-Eviction Act is, simply put, the body of law that exists here in New Jersey, right, to protect the rights of New Jersey tenant. Right? Specifically, the Anti-Eviction Act is called the Anti-Eviction Act. It's not called the Helping Landlords Get Rid of Tenants Easier Act, right? It tells us what it wants us to know about it by its very title. And so it is a body of law, mostly by statutes, that provide individual protections to tenants.
Okay.
In around 1973, it was determined that there was a severe shortage of housing in New Jersey, and that the tenants who had leases and rentals, they needed to be protected so they wouldn't lose that housing, because there was a shortage of housing that could substitute if they became homeless.
I see. Okay. And so those occupants of rooming and boarding homes, are they do they have the same rights and protections under the Anti-Eviction Act as does somebody who has a more traditional tenancy, let's say?
The simple answer is yes.
Okay.
Simple answer is yes. Um, right? Because in New Jersey, this is the shorthand, not the exact definition. But in New Jersey, if you've if you signed a lease, although doesn't have to be in writing, or you can enter into a verbal lease. But if you paid rent to a landlord, then you are subject to the rights provided to all tenants under the Anti-Eviction Act. And so, what this means is, generally speaking, in rooming and boarding houses, a landlord can't just toss the tenant. Now, if there are other issues, I can think of one boarding house that no longer exists in Morris County that was directly over a bar, right? And so they the they used to be frequent bar fights, so then they could toss them, they could kind of get them arrested if they were in a bar fight. Um, Meaning sometimes are there extraordinary, things that can happen. But simply put, as it relates to the tenancy matter alone, they are protected by the Anti-Eviction Act and all of the rights there.
Okay, lovely. Very good. I'm glad that we got that covered, because for some of our attendees and viewers of this material, it's important for you to know that your rights are protected under this act as if you had a traditional tenancy. So very good. And
And if Frank, if I can,
yes,
just
of course.
so what
Of
that
course.
means is, for those maybe who are watching this, or know somebody who lives in a boarding or rooming house, right? That what that means is, even if a landlord comes along, right? These landlords here in this context might try to just do what's called a self-help eviction, right? That's it. The best thing you can do is know about that and know that it's not appropriate. And so, if a landlord tries to do what's called a self-help eviction, even in a boarding or rooming house, right? The, you don't have to go. And simply put, you could call the local PD, right? Local PD, and let them know that the landlord is trying to toss you, and the PD will come along and tell the landlord that he can't, that he must, this is a legal matter. He must file papers with the tenancy court in the county seat, and then try to evict them.
Okay, that's very good. Okay, excellent. That's so helpful. Thank you again, David, for breaking that down and providing that advice to our viewers. Super important and helpful information, invaluable, really. So that's excellent. So, one of the things as we move along, one of the things I wanted to ask you about, and I don't know if you know about this, if this question is a little off, if it's too specific or if it's out of context, and if it is, just let me know, and maybe you can help shed some light on it. One of the phrases I came upon when I was reading up on the subject as it pertains to protection against eviction for those who occupy rooming and boarding homes, and specifically in the context of the Anti Eviction Act, was its displacement due to code enforcement. What exactly does that mean?
What it means is something's wrong with the place, right? There's a
Okay.
code enforcement issue, meaning there's no water, there's no heat, there's no hot water, there's the toilets don't flush, the windows are broken. And so a displacement due to a code violation is again, perhaps when we think about a rooming and boarding house, right? That is probably our least well-maintained housing stock that we have within the state or within the county or whatever. And so that term you come across that term just because landlords, think about a boarding house, right? It's the local house that everybody's seen, that's been there for 150 years, that no one really caring about. And a landlord might own that and rents out the rooms, in Morris County, $800 to $900 a month. And so gentlemen, mostly gentlemen, doesn't have to be gentlemen, but gentlemen who are single may want to come live there and not have to have a full apartment, or they may not be able to afford. That's mostly what happens. And
Mhm.
so, if again if and when some of those things, deferred maintenance is something that comes to mind. When deferred maintenance isn't taken care of, right? A tree falls on the roof and no one fixes it, and now it's got a hole in the rain leaking in. Those might be reasons why code enforcement came out. And so one might be evicted untechnically, not officially evicted, but put out of the premises due to deferred maintenance by the owner.
I see. Okay. And is there any remedy available to those tenants who are evicted or displaced rather because of that code enforcement?
So the simple answer is they can seek. So when a tenant is put out of the premises, now again, even in rooming and boarding house context, right? They're still a tenant. There's relocation assistance as protected by a different part of the act. Relocation assistance when a tenant is put out due to no fault of their own. Think fire, flood, because we've had that both situations. When they're put out due to no fault of their own, then they can seek what's called relocation assistance, or perhaps a landlord of an apartment building. He has got 2 units in the apartment building, but he's going to go in the basement and put a 3rd unit. It's not really above board. He does it, on the quiet and on the cheap. And when eventually the town always finds out, because the town always finds out. And so sometimes the town will come along and they will shut down that illegal basement apartment. Illegal basement apartment is just happens all the time. And so the illegal basement apartment, when a tenant is put out of those premises, they can seek what's called relocation assistance. And under the act, a tenant can, now here's where it sounds magical, but it almost never works out this way. A tenant can seek relocation assistance, which means they can get up to 6 months of rent that they have paid over to the landlord if they're put out of the premises. And so this relocation assistance, again, sounds great, but it doesn't always work in practical terms.
Gotcha. I got you. Okay. All right. Excellent. Thank you. Okay. So we're going to go ahead and move along then to the other rights of boarding home residents. So let's go ahead and move on to the next slide. So Dawn Hendershot, my colleague here at Family Promise of Sussex County, has helped put these slides together. And this follows the Legal Services of New Jersey's Landlord-Tenant Manual, what's often referred to colloquially, I believe in your office, David, as the Brick Book. This manual, the law says that every resident of a boarding home has the right to, and it touches on some of these rights. So I just wanted to read this for the class, for our attendees this evening, and anybody who may be viewing this video in the future, that these are rights that you get to enjoy as an occupant of such a dwelling, of a rooming or a boarding home. So the law says that every resident of a boarding home has the right to manage his or her own financial affairs, wear his or her clothing in the style he or she prefers, style his or her hair according to his or her preference, keep and use personal property in his or her room, except where the boarding house can show that this would be unsafe or impractical, or that it would interfere with the rights of others, receive and send unopened mail, unaccompanied use of a telephone at a reasonable hour and to a private phone at the resident's expense, privacy, hire his or her personal doctor at his or her own expense or under a healthcare plan, privacy concerning his or her medical condition and treatment, unrestricted personal visits with any person of his or her choice at any reasonable hour, be active in the community, present complaints of his or her own self or others to government agencies or other persons without threat of reprisal in any form or manner, a safe and decent living environment and care that recognizes the dignity and individuality of the resident, refuse to work for the boarding facility except as contracted for by the resident and the operator, practice his or her religion, not be deprived of any legal rights solely because he or she lives in a boarding house, and be free from retaliation by the owner if the resident tries to stand up for or enforce his or her rights. Now, it seems that a lot of these things that I just read seem very commonplace, like common sense. Like, yeah, of course you can style your own hair the way you want to. Of course you can select your own doctor. Of course you have the right to privacy, the use of a telephone and using certain, amenities and so forth. But David, why has there been such painstaking, amount of time devoted to identifying these particular rights that otherwise in a more traditional tenancy might seem rather commonplace and intuitive? Why in this instance are these rights so specifically either numerated or compiled in this particular list?
I think I want to give three answers to that, right? The first one is I think some of these are just flat out dated terms, right? 50, 60 years old, something like that, right? They're dated terms, and so no one cares how you keep your hair, generally speaking, right? Two, it's due really to the fact that there's communal living going on here, right? And so folks are living, they may not be sharing the same rooms, right? But they're sharing some of the same open spaces. They're definitely sharing, if there's kitchen space, they're sharing that. If there's, bathrooms and shower space, they're sharing all that. And so there's much more communal living. The third thing I want to say is there's, again, the rooming house, I think, is sort of a dying concept, if you will. But I think in the past, it was a rooming house landlord could be a little bit of a despot and sort of try to dictate terms. And frankly, again, so the ones I've seen, that's exactly what happens, right? The owner of the property is sort of the barn boss, and he gets to, it's almost invariably he thinks he gets to dictate terms to all the people who live there, because if not, they'll throw them out on their ear and they'll never come back here again, right? And so I think these rights, as you reviewed them, I think they're important. I think if I can, the one that jumps off the page to me that sort of come over and over again we see is unrestricted personal visits, right? Because invariably the folks want to have folks visit them, and for people who live in rooming houses, right, the landlords don't want that to happen, right? Because they're concerned that if you got a friend who's coming to see you at night, maybe that friend is your secret tenant, and he's not paying to live. That other person's not paying to live there,
Sure.
right? And they're losing out on money. The personal visits over and over again, that seems to come up.
Gotcha. Gotcha. Okay, very good. And so, is there any kind of, with regard to these rights that I've outlined in the slide and read to our class, is there some kind of notice? Like, is there some kind of like paperwork that the landlord or the owner of the rooming and boarding house has to present to an occupant of the rooming and boarding house with regards to
I
these
think
rights?
Yeah, no, I think the answer is yes. I'm going to actually check the text while we're talking about it. I think all of those need to be posted somewhere within a rooming house.
Mhm.
And I bet if you found a rooming house and you try to find where they were posted, you might get the original version. But they're supposed to be posted. I forget where. Maybe at the bottom of the stairs or something like that.
Mhm.
But they're supposed to be there so that folks can see them. It says here in the brick book, the owner must give each resident written notice of these rights, and the notice must be posted in the home. The notice must include the name, address, and telephone number of social services agencies, including the Office of the Ombudsman for the institutionalized elderly, the County Welfare Agency, or the County Office on Aging. Any resident whose rights are violated can sue the offender. The resident can ask for actual and punitive damages, reasonable attorney's fees, and the cost of the action. So yeah, they need to be posted there. Right. So again, sometimes what you find is, folks who may not have a better option. They're, maybe they're the last person in their family who's around, who hasn't moved away. Maybe they're the last person in their family who's still alive. And so maybe they're older, maybe they're infirmed, maybe they have substance abuse issues, something like that. And so what you need to know is, just by sort of what Frank and I are saying, is simply put, that there's an attempt by government to give additional protections to those live in rooming houses, because they might be sort of on the margin of society a little bit. And
Sure.
of course, I don't mean any insult by saying it that way.
No, no, I completely understand the context that you're referring to. So, and it's important to make sure that they're apprised of their rights, and apprised of how they're given notice of those rights and what remedies are available if those rights are violated. So, hugely important, David. Thank you for the information as it pertains to rooming and boarding homes and the rights that exist there for those particular occupants. So, if I may, I'd like to go ahead and move forward with protections for mobile home tenants. So, why don't we go ahead and jump on to the second half of this particular lecture? So, we're going to talk about mobile homes. So, what I'd like to ask you, as we covered with the Anti-Eviction Act and as it pertained to rooming and boarding houses, are the same protections under the Anti-Eviction Act available to occupants of mobile homes?
No. Yes and no. Generally speaking, the answer is yes, right? Everybody gets the same rights. But if you, it's different because if you own the mobile home, right? The ownership of a mobile home, you can bring it there, and in theory, the landlord could evict you for not paying the ground rent, but you would still have ownership rights to the overall to the trailer. And so it is a really kind of a different dynamic, right? In a rooming house, the landlord owns the property. They own the walls, they own the doors, they own the windows, they own everything. But
Mhm.
here, you could bring your mobile home to mobile home grounds, and the rent is somewhere $600-800 a month, maybe $900 a month, depending on what neighborhood
Okay.
in New Jersey that you're at. And so the rent is significantly less. Um, Part of what the, when somebody owns a mobile home, it's really a whole basket of things you hadn't even thought about. Very frequently, what happens is motorhomes are that they're built to last maybe 15 or 20 or 25 years. They don't last as long as a house that's built on a block foundation on the ground. And so what happens is, even if you bring your motor, you find a nice place you want to live, right, in Warren County, you bring your motor home, your mobile home there, rather, not motor home, mobile home there, and you park it in the ground for the next 10 or 15 years. It may not want to move when you do in 10 or 15 years, right?
Yeah.
They're frequently not built on a foundation, therefore they can sort of kind of sink into the ground. Sometimes to move them is difficult. You have to get them trucked in and out like by a big old tractor trailer, so that's not quite easy. Further, sometimes they'll, because the property gets old and just life happens, time happens, that they might want to break, so they maybe can't be moved. And so what once was mobile is maybe now no longer be mobile. And so there's a whole different basket of problems that sort of come up with this type of housing.
I see. Okay. So let's go ahead moving forward. So now what I wanted to ask you, as we're talking about those rights that mobile home occupants are privy to, and it sounds like it's a little different, based on the structure and the relationship under the tenancy as it pertains to mobile homes. Uh, but in that same vein, then are there additional protections that mobile home tenants get to enjoy?
So I don't know that there's additional. I mean, there's additional concepts, but I don't know that there's additional. I find again that perhaps mobile home folks who live in mobile home, maybe it is a little bit more marginalized, and
Mhm.
so they maybe government cares a little bit less about whether things are complied with there down at the mobile home
I
park.
see. Okay. Okay. Very good. And one of the acts, or I guess maybe the controlling or applicable laws that I've seen when I've been reviewing this particular material is the New Jersey Homestead Property Tax Credit Act. Are you able to tell our attendees and the class this evening what exactly that is and how it's applicable to occupants of mobile homes?
So I'm a little embarrassed to say I cannot.
Okay. Okay. Yeah, neither can I. So, but how about the Mobile Home Act? Is there anything in there that we might be important for us to know this evening?
Sure, sure. Simply put, I mean, you have it here in your slide, right? And
Mhm.
there's some little bit quirky things that go on here, right? It
Mhm.
requires the park owners to give at least 1 year written lease to all renters of space within a month after they move in, right? So in essence, they in their first year they get a 13-month lease. The idea there is to give you've brought your mobile home there and you want to make sure it's nice before you really commit to moving in all the way. Um, Again, they cannot ask a tenant to move their home within the park unless the move is reasonably necessary and 30 days notice is given, right? And so landlords sometimes do this, right? There are in many mobile home parks, there are nicer parts of the park and there are less nice parts of the park. And so sometimes folks will get that down by the river, down by the stream, down by the lake, right? They'll want to be there, but sometimes the landlord will increase the prices for those down by the lake, and therefore, now the tenant wants to move his mobile home away from that. Again, generally speaking, they give them 30 days notice, and they can, we want to try to move them only as reasonably necessary. They must make known, and this is an important one for real, they must make known all fees, charges, assessments, and rules in writing prior to move in, right? Every mobile home park will have rules. Very infrequently do the people see the rules by the time they move in. The rules, there are a lot of folks who live in mobile home parks for a good long time. The rules are known to them because they live by them, on a daily basis, but landlords are pretty bad in getting that information out to them. With progress, general progress, meant in the 1960s kind of way, with progress, mobile home parks, especially if they're very large and if they're in a nice area, they've sort of lost some of their pull, again, here in New Jersey. And because what happens is if the property is large enough, it's no longer perhaps marginal land, and perhaps developers want to buy out these properties, build permanent houses on them because they think they can earn more money. And so sometimes that's some of the things that happens. Going back just a moment, right, to making all fees, charges, and assessments, that these parks are generally, well, A, not a park, but B, these locations are generally known for sort of trying to nickel and dime folks for their space there, right? There is the local ground rent. The ground rent is $800 a month. I'm making that up, right? But then there might be additional power fees, hookup fees, right? When you first get there, there's a fee to have a wire attached to to your mobile home, the electrical wire, right? For sewage purposes, there's a hookup fee for that. And so for water coming in, there could be a hookup fee for that. And so what you find over time, simply put, is that there are a lot of nickel and dime fees. Plus, then the park tries to get folks for regular stuff that folks might think about they would have to pay in a regular neighborhood. Garbage fees, for instance, things like that, right? Other services that come in. And so before you know it, there's a lot of fees that come along. And so that $800 monthly rent that seems so reasonable at the beginning, after a little while seems maybe not so reasonable towards the end.
Sure. Okay.
Right. And specifically, just go along, they must provide proper notice on rent increases. That's required under the Anti-Eviction Act as well. But certainly because, again, you may not be able to move your property, the mobile home, right? They certainly have to let you know within reason. And they're responsible for the general upkeep and any services agreed to in the lease. I want to take it just a step back. A lot of times what happens is we see, again, not so much maybe in Morris County where I practice, but in Sussex or in Warren or in Hunterdon County, where there still are some mobile home parks, what happens is the landlord gets used to whoever lives there and they pay whatever the ground rent is per year, and they're satisfied with that. And maybe over long periods of time, they don't increase rent, 5, 6, 7, 10 years, right? Other rent goes up marginally, it goes up $20 a year or something like that. Right. And I've seen a couple of them over the last few years where bigger landlords come in and buy up mobile home parks, and they say, well, this is below market rate. You're getting $640 per lot space. Now we're going to jack it up to $850 per month, which doesn't sound like a lot, right? But then on an annualized basis, it is, along with some of those nickel and dime fees. And before you know it, they're getting kind of close to a regular market rate apartment.
Yep. Yep. Absolutely. Yeah. So, and I wanted to ask you, in line with with fees and everything like that, can a mobile park owner, can they require any of their tenants or the mobile home owners, can they require them to or force them to buy equipment at a particular outlet, or have a certain type of mobile home for the lot that they occupy?
So the simple answer is yes, right? So sometimes it's just based upon size constrictions, right? The larger your mobile home is, right, the more it has to be parked in a lot that's, parked in a part of the park that can accept a unit that's big. As it relates to certain equipment, I think the simple answer is yes, and I'm actually in favor of that, and there's a reason why. There's for folks who live in those communities, there are certain products that are known to be safer, right? think for heating purposes, right? There's frequently restrictions on as to how you might be able to heat your motorhome, right? Certainly, open fires are discouraged in the best possible way, right? And
Right.
so there's certain equipment requirements that I've seen that sort of make more sense. They tend to seem to be more expensive in the way that you have this type of furnace or you have this type of electrical heat, but they also seem to be some of the safer products used there. One of the things that, Frank, you didn't mention, but I sometimes seen as well, some more terrible landlords also will require tenants to do certain chores,
Hmm.
right?
Right.
You live in this part of the park, so therefore you got to pick up all the sticks in that part of the park, or you have to mow the lawn, or you have to do this or that. And so again, I think it's not on any lease probably anywhere that they have to do chores, but I don't know. I've seen it before.
Oh, wow.
I've
Wow.
seen it. I've also seen some weird requirements. One specifically was that in a mobile home park where if it was in a forest, right, and so that if sticks fell on your roof, you would have to clean off the sticks, right, and in a way that seems fine. Like nobody wants to see the sticks up there, I guess. But then there were a lot of seniors who were living in the mobile home park, and the
Sure.
seniors generally couldn't get on the roof of the mobile home because they were seniors and maybe they were unable to get up there physically. And
Sure.
so, stuff like that happens where some odd things. And I think some of these landlords get away with requesting some of these odd things like chores or picking up sticks off the top of your roof because again, it's somewhat marginalized housing and maybe no one really cares if they're asking for weird stuff.
Gotcha, gotcha. But generally, are you saying that generally a clause like that in the lease, is that generally acceptable? Is that enforceable? Like grooming
I think
certain
so,
areas
yes.
of the park? Okay. Okay.
I think the grooming part, no, not a
Okay.
chance, right? But I think like having certain safety equipment, that you have to have
Right.
a fire extinguisher. That makes a ton of sense, right? That you have to have this certain type of heating, service. That makes a ton of sense.
Okay.
But not as to like the cleanup and the responsibilities, right? Again, there's sometimes these places are like their own little kingdom, and maybe no one cares, and so some of the landlords get away with some stuff that is enforceable down at the park, but not anywhere else in the world.
Gotcha. Right. Okay. Okay. Good to know. Um, you may have touched on it already, but I just wanted to just back up to it if you did, speak on it already. And again, thank you, David. A lot of really excellent information. But I wanted to ask if you could just touch on this again with regard to once someone is within the mobile home park, they've moved in, they've gotten their written lease once they've moved in. Can the owner of the park uh, just have that person move within the park whenever they feel like it? How does that work? Like, let's say there was some like can they just just say, hey, you know what, I want you over on this side of the park instead of this side of the park? Like, is there have to be specific reasons? If so, what are those reasons?
So right, for some of these owner requirements they have here on the slide, right, that it's got to be reasonably necessary, and I can point to things that are not reasonably necessary and some that are, right. In as you move every year from the winter to the spring, right? If you're somewhere near a river, right, the river might swell, and so it might be reasonably necessary to move your mobile home, right, so it doesn't get flooded and carried downstream. That seems like a reason that would be perfectly reasonable. Um, Sometimes when a landlord is just annoyed with somebody and wants to get rid of somebody, right? They might stretch the definition of reasonably necessary and do it more often than necessary. But again, I think it's if you drive down to any mobile home park, you'll find that again, perhaps there might be some deferred maintenance, right? There might be some properties that are in need of repair, and so sometimes the moving of them might not really become possible. And so
I see.
when landlords frequently want them moved, and they do it all the time, it begins to feel like harassment to to individual tenants, and maybe it's they're trying to get them to move someplace else. But again, with deferred maintenance, sometimes they can't move the units, whether they own them or not, and it puts people in a jam.
Gotcha. Gotcha. Okay. And so if they do end up moving that person, it looks like it says, when they do find it, as per the slide, when it says if it's deemed reasonably necessary, it looks like there is notice that is required. Do you ever find yourself in court, David, having to litigate the legitimacy or the propriety of a notice in these particular instances?
I can honestly say not once.
Okay, that's good to know. But again, this information is certainly helpful. So even if it's not being litigated in your particular experience, for those, especially in this area, we do have several parks in Sussex County, mobile home parks. So it's really important for our viewers to have this information and to know your rights and to know when to enforce or let the owner or your landlord be apprised of those rights and to assert them. That's certainly very important. So as we move along with the information here as we're covering it, let's go ahead and move on to our next series of questions. So let's talk about, again, selling. So we've talked about moving the mobile home. We've talked about what is required when someone is moving, and what is required in terms of the notice. So again, as David had mentioned to the class, that mobile home park owner cannot just ask a tenant to move, their mobile home just on a whim and wherever they feel like it, especially in those instances where it seems like it's bordering on harassment. There has to be some reasonably necessary circumstances, as outlined by David and exampled by him, if there's a flooding concern, for instance, and things like that. Per the Brick Book or the LSNJ Landlord-Tenant Manual, it seems that 30-day notice is written notice needs to be provided. Or does it have to be written notice, David, or is it just 30-day notice?
I would always do it in writing if you could, but I don't necessarily think it needs to be in writing.
Okay, very good, very good. It also mentions that in an emergency, the operator may move the mobile home, but is responsible for all costs or for any damages to the mobile home resulting from the move. When they say the operator, are they referring to whoever moves the mobile home, or is it the park owner?
I think it's one and the same. The
Okay.
one who would move it is likely the operator of the park.
Okay, I see. Okay, very good, very good. Okay, so let's go ahead and then move forward as we round out the mobile home subject. Let's talk about selling the mobile home. So let's go ahead and touch on the next question. So, can the owner of the mobile home or the tenant in this instance sell their mobile home whenever they feel like and to whomever they feel like?
Well, the answer is simply is yes, right? Um, but there's a series of, I think, like not impossible, but there's a series of high level requirements, right? Because you have to consider if they're selling the mobile home because they want to move it elsewhere, or they're selling it to some other person who wants to move in there and live on the grounds at the park as well. And so um, a homeowner who plans to sell his house must give written notice to the park owner. It's unlawful to try to sell a mobile home without the park owner's consent or knowledge, which is just crazy, right? Before selling a mobile home, the seller must give the buyer an application for park tenancy. That's if they're going to stay on the premises. The buyer must then return the application in person to the park owner or operator. Then a park owner has the right to approve who buys a mobile home in the park, but cannot deny anyone without reason. Right, we're talking about discrimination there. If the
Right.
park owner unreasonably refuses to approve the buyer, the homeowner or the intended buyer can sue in the superior court. The court can award damages, costs of lawsuits, and attorney's fees. The court may also require the park owner to rent the prospective buyer. A valid reason for refusal would be unsatisfactory credit report on the prospective buyer. And the park owner can refuse to approve an interested buyer if the park has been legally designated for senior citizens and the tenant is below the minimum age requirement. That's really enforceable. However, in a park that is not reserved for seniors, discrimination against buyers with children may be against state and federal law. And if you have questions, go to talk to legal services. All right, that's what the book says, right?
Absolutely.
But those are some of the requirements, right? And again, I think those apply less if you're just going to sell it to somebody who's going to take it somewhere else down the road and put it on their own property.
Right.
But the landlord isn't required just to take whomever you sell it to.
Okay. So
And so I think that setup is really rife for just lots of discrimination type complaints, right? I want to
right,
sell it to the local. I want to sell it to the guy who just got out of jail on a 30-year bid, right? In theory, the landlord has some control over who comes in.
right, exactly. So, okay, as outlined in the manual, and I appreciate that, David. Basically, in that particular instance, so we're not talking about the unit, it's the mobile home itself being sold to someone who plans on using it outside of the park owner's property. This is if they wanted to sell it, transfer ownership of that mobile home to someone who then plans on occupying the mobile home within the park. So if that be
Mhm.
the case, as you've outlined, it appears that they have to put the park owner on notice prior to the sale, have to have their consent or knowledge. And then the application for tenancy at the park has to be given to that prospective buyer. The prospective buyer has to then return that application in person. And then the park owner has the right to choose who then ends up taking up tenancy within the park, but they cannot discriminate, without reason or without good cause, it sounds like. And if that is done unreasonably so, it looks like the intended buyer and the homeowner have some remedies in superior court, and they can sue for awarded damages, cost of the lawsuit, and attorney's fees.
Correct. And
Okay.
if I could just sort of illustrate that further, though,
Yes, sir.
I've seen where, in an instance, oddly enough, in a case that I helped litigate just this past year, the
Hmm.
beginning of the year, and where a park owner, evicted a tenant for not paying the ground fee, some $640 per month. Um, but they owned the unit, right? They literally owned the mobile home.
Mm.
And so at the time of trial where our client went unrepresented, he didn't approach us, so we didn't know this happened. He entered into an agreement with the landlord that he would give him, I don't know, 30 or 60 days time, but then he would, in lieu of paying the rent that was unpaid on the ground, that the landlord convinced him that he would just give him over the whole unit, and just walk away. And so for a mobile home unit that was worth something like, 28, $30,000, he lost it because he couldn't move it, right? But he lost it for the value of $2,000 rather than 28 or $30,000. And
Wow,
so we had sued on behalf of the tenant. A, did not get him evicted, but B, also to force him not to sell the property.
that's
And
excellent.
eventually we had a really good result based upon some terrible facts, but we got a good result for the client.
Excellent. Thank goodness for the hard work that you and your team put forth and do that zealous advocacy and representation, because otherwise it sounds like this is something that happens, and people are left high and dry, and they're forced to undergo circumstances or procedures that otherwise are in violation of their rights or violative of those particular rights. So certainly appreciate that, David, and appreciate everything you and
Thank
your
you.
team do. And certainly appreciate the information that you've reviewed with us. So, and we'll keep moving along. So, as we kind of cap off the evening, we are almost finished up for this evening, and with regard to this particular topic. And it looks like I think we might have covered this already. Um, as we have been going about this particular subject. But I just want to just touch on it again. And David, if there's anything you'd like to add, please feel free to interrupt me or add on to anything that I may say. But it sounds like as we were talking about fees and the disclosure of fees, is that the mobile home park owner must make known all public fees, charges, assessments, and things like that, and that the disclosure must be given in writing before any prospective mobile home owner moves in. And that it looks like if they're already there and there's any additional fees that may be incurred, or that the landlord or the owner, I should say, of the park plans on charging, that at least 30 days notice prior to the effective date of the enforcement of those fees, at least 30 days needs to be given. If the written notice is not given, the park owner cannot use a mobile home's owner or a mobile home owner's failure to comply as a cause for eviction. So just to kind of reassess that paragraph from the LSNJ manual, what I'm saying, or what the manual is saying, is that if there's any fees, assessments, charges, or rules, they need to be made known in writing prior to the move-in of the mobile home owner. So the park owner has to make known these rules, these charges, these fees, these assessments, make them known prior to move-in. And if there are any additional that come out during that occupancy, that the landlord, or excuse me, the mobile park owner needs to let the mobile home owner know of these additional fees within 30 days of their effective date. But if notice is not properly given, the mobile home owner's failure to comply should not be cause for eviction. Does that sound like a fair assessment, David?
Oh, I think it is. And the
Okay.
good news about it is, right, is that again, under the Anti-Eviction Act, right, which again is the body of law, designed to protect tenants in New Jersey, the increase in those fees, right, can be a reason to evict a tenant. So here in a mobile home complex, that they are given perhaps some additional rights, and that can't be the sole reason. Again, they can be evicted for not paying the ground rent, but if the landlord comes along and says, now I'm going to start charging a sewer charge, now I'm going to charge a water fee of $15 a month where I never charged it before, and so that they can't be evicted for those new fees is really, again, it's an additional layer of protection, which I'm pleased about.
Excellent, excellent, very good. So, and then as we finish off this particular subject with regard to the disclosure of fees and so forth, um, it mentions in the LSNJ Brick Book, it talks about donations and gifts. So, but are you able to speak on this, David? Are owners of the park able to accept donations or gifts for the rented space?
So it depends how you ask that, right? One, can they accept donations, right? One of that case I just mentioned a few minutes ago, right, where they
Right.
were looking for a donation of the value of a motor home, mobile home rather. So that's one, that was an exchange that they could make. What they try to do though is going back to, I think, what the real literal the language means that you just brought up, right? Is I think they're trying to avoid any type of favoritism amongst tenants in
Right.
receiving stuff, an extra gallon of milk or a dozen eggs or something like that. Um, and so in some ways, I think, yes, it can happen, but in other ways, I think it can't.
Gotcha. Okay, excellent. Very, very good. And let's see. And again, I believe we've been talking about it throughout this entire this particular subject, but I wanted to just bring up the point again. And again, those Anti-Eviction Act protections are available and are enjoyed by mobile park or mobile home tenants as they would be with a traditional tenancy, as they would be with room and boarding home tenants as well. So does that so with and again, as we speak specifically to mobile homes, David, are habitability claims still something that can be brought by someone who is the occupant of a mobile home?
Yes, but again, I think it goes back to who owns the home itself, who owns the box that you live in. If you own the box that you live in and there's habitability issues, they might be your problem.
Yeah.
But
Okay.
if you're renting the box that you live in from the mobile home park, then I think you have significantly stronger claims for habitability, right? Habitability, when we talk about that, that's perhaps a fancy lawyer's word for just the living conditions that you're in, right? Everybody's entitled to get fresh water. Everybody's entitled to hot water, right? You're entitled to get heat. You're entitled to cold water, right? Not to air conditioning and not cable TV, but you're entitled to get those things. And so if you're not getting those services, for instance, habitability, regardless of who owns it, is, sewerage, like for the raw sewage, that's clogged and it doesn't work, and the landlord needs to have someone come and address that. So those habitability issues again are vary, depends on who owns the box, right? But also I think they're more expansive. If you own a home, right, in Sussex County, you own the land, hopefully, right, and then you're responsible for the sewer lines and the water lines and the everything. Those are all your responsibility. But when you rent in a motor home, the landlord is likely responsible for lots of those. And so again, I don't know if you have more protections, but I think in a way you have more more at risk with some of those things that are out of your control and responsibility, and are in control and the responsibility of the landlord.
Sure, sure. Okay. And is that also true with regard to rent increases? Are they the same protections under a traditional tenancy
Yes.
for the Anti-Eviction Act? Okay, very good. So rent
Yeah, no,
increases.
that's a simple answer, right? And it
Right.
said in the previous slide that they had to be 30 days, right?
Right.
Yes, also in a traditional tenancy, it's generally 30 days, right? And again, if they do it right, they have to give a notice saying, here's your old lease is terminated. Here we're offering you a new lease at this increased amount. If you choose to stay, you'll have to pay this increased amount.
Mhm. Excellent, excellent. All right, very good. Well, I think that pretty much wraps up what we had planned. So, just we have this final slide for the Manufactured Homeowners Association. So, there is an association of mobile home owners that can provide information and other assistance to mobile home owners. So, if you do find yourself in a situation that touches on what has been covered by David or myself this evening, please feel free to reach out to the Mobile Home Owners Association. Their P.O. box is featured there and all of that address information. There's a phone number featured on this slide as well as their website. So please feel free to reach out to them for any additional information. They may have staff attorneys or any professionals there that might be able to guide your inquiry. And then, of course, as always, any questions that any attendees that may have, whether it be live or whether it be virtually, that may have questions going forward that have legal consequence and you need some advice. Of course, Family Promise is here to help you through whether you're have a housing insecurity issue, whether you're dealing with the crisis of street homelessness, any legal advice that you may need, we will always defer to or refer you to Legal Services of Northwest Jersey, which is a branch of Legal Services of New Jersey. And we can put you in contact if you're in Sussex County. We have, of course, the Sussex County office, and we have David in the Morris County office. So, we want to make sure that you have those resources available to you as well. But please feel free to call our agency, and we will direct you in any way that we can to provide you with the services that you need. I want to just take a brief moment. As I did mention at the beginning of our class, we do have, as I've been checking regularly, I don't see any online inquiries. Do we have any questions from our live attendees? Yes.
This is hyper specific, but are there any rights in place for people who are in motorhomes or trailers in seasonal communities, and what they can do if there's an introduction of an off season where they're supposed to live during winter?
Did you hear that, David?
So I didn't. If you could repeat it, that would be fantastic.
So I believe what she had asked was if there are are there any, she said it's a rather specific, but are there any rights to somebody who is asked to leave a community that is seasonal in nature, and what they can do when they're asked to leave if they, what if the park is closing for a
Like
season?
if they turn the water off in winter, they're not going to keep up maintenance until the spring. That
Right. Yep. So, David, we have a lot of clients here who may be occupying a lot at a park that is seasonal in nature, and the park staff has approached these individuals and said, "You got to get going because we're shutting down for the season." Are there any rights that they may have in occupying those lots or that land, and what's available to them in the event that they have to leave?
Right. I'm going to say I don't rightly know. I'm going to give an educated guess. I think there isn't, so long as at the inception, right? I'm thinking of another park. I think it would have been northern Morris County, called Goodlands. Goodlands just shut down just this past summer. And they had an outdoor pool and everybody loved to go there, and it was wonderful. But it was, generally speaking, it was a 8 or 9 month out of the year park. And so they as long as you advertise up front and let people know, hey, this isn't a sleeping here all year round park. Simply put, we're only here for the spring, winter, fall. I'm sorry, spring, summer, fall. And we're not a winter park. I don't think there's any remedies available to individuals who are asked to leave at that time. Again, it becomes a difficult thing where there's issues with the box that you live in, or if there's issues with removing or things like that, that's a different story. Or you can't trailer the thing out. But I don't think that there's any additional available rights to them.
Okay. Any other questions?
No, thank you.
Okay. Thank you very much for your question. I appreciate that. So I'm just going to check once more to see if we have any questions on our live stream, which I don't believe we do. So we're going to go ahead and wrap up for the evening. And Dawn, as always, puts these really wonderful, thoughtful, insightful quotes. So small rooms or dwellings discipline the mind, large ones weaken it. Leonardo da Vinci. So that's something certainly to think on and dwell on, and really appreciate her insightful, thoughtful, and really the time she devotes to these slides in general. Thank you so much, Dawn, to the wonderful work that you put in, the effort that you put in and week out to help us have a visual presentation for our attendees to follow while our guests break down this rather complex material, certainly for us lay people who are as well versed in the law. It's certainly helpful to have that visual element. And it's certainly tremendously helpful to have someone like David and the other staffers of his office, as well as our other guests who have been able to so eloquently and thoughtfully and thoroughly expand on the subject that we've been discussing in this particular curriculum. I also want to thank Jamie and I want to thank Tori, who are also part of our staff, who put together the tech elements here. They've helped develop the live stream elements. They've helped purchase the tech so we can film and record. And once we record, they help edit the videos. They help pair them with the slides. And again, the countless amount of time and effort that they put forth to make sure that the information is brought to the public, our clients, our prospective clients, landlords, tenants, area practitioners, service providers, to ensure that everybody can be part of the solution. The whole purpose of STEPP so that we can have more peaceable civil tenancy transactions in our community. And so people are more aware of the rights of the other involved in these transactions, the less litigious these matters have to be. But in the event that they are litigious, they are armed with the information they have so they can more successfully, discuss their matters, and hopefully they're discussed peaceably as best as is possible. But again, one of the through lines of these communications, or these, I should say, rather these modules that we've been having, is that in the event that you find yourself in one of these situations, it is always advisable to seek legal counsel. If you cannot afford a private counsel, please, as early as you can, get involved with Legal Services of New Jersey. And in this area, I believe, you've got Warren, Hunterdon, Morris, Sussex. Is there another county, David, that encompasses Legal Services of Northwest Jersey?
Hunterdon.
Oh, okay. Okay.
Hunterdon, Somerset. So
Somerset.
Hunterdon, Somerset, Sussex, Warren, Morris.
Okay, excellent. So please, those of you who are in those counties, please, Legal Services of Northwest Jersey, they are rather available. They have an online presence, but you can always call Family Promise of Sussex County as well, and we will refer you to the appropriate service. So I want to thank our guest this evening, David Saltzman, who is the attorney. He's one of the attorneys at the Morris County office. He does strictly tenancy law, and he's one of the managing attorneys there and oversees that staff. And they are absolutely excellent. And I appreciate everybody is there, from Sonia to John and Randy and Maria and everybody who's over there. Really just a great thank you to all the wonderful work that you do and for being part of this class with us as well. Greatly appreciate it. Appreciate everybody's time. And thank you again to the New Jersey State Bar Foundation. It's been a wonderful experience to be able to teach and present this information and have different community professionals be involved and help teach these modules and be part of this community effort. So thank you with the most sincerest and deepest gratitude. I thank you so much for the funding to allow us to present this material. So thank you to everybody. Thank you to our virtual attendees. Thank you to our live attendees and your excellent questions. Had a lot of fun presenting it tonight, and we are rounding out the material. So sad we are coming to the end. Next week will be our last class. Tomorrow we have one more pre-recorded eviction only video as it pertains to, or as it's experienced by the tenant. And then I will be around for live Q&A. And then next Tuesday at 5:30 will be our final course. and that will be on area services. So if you find yourself in an eviction matter, or if you find yourself struggling with the rent, or if you find yourself displaced, or in any one of these situations, that class is going to focus on what services are available to you in your area. So we're going to look forward to that one. And just thank you again to everybody. Once again, thank you so much for your time and devotion, David. It was an excellent class. And again, your answers are always so thoughtful and thorough, and really appreciate all of your professionalism and thoughtfulness. Thank you very much.
Oh, thank you. Thanks for inviting me. Appreciate it.
Thank you, everybody. Have a wonderful evening. Take care of yourself, and we'll see you next time. Bye now.
Bye-bye. Take care.